All right, good morning, everyone. I'm going to go through my decisions on the four pending motions. They're kind of grouped as two groups of two. I think the Dr. Vincent evidence is intertwined with the May 6, 2019 reverse Spriegel that the defense has proffered. And I'll go through the analysis and it'll hopefully become apparent why I see that they are intertwined. First of all, I'm going to deal with the May 6, 2019 incident because regardless of where and when we try this case, we have to decide this evidentiary issue. So, in analyzing whether anything from the May 6, 2019 case is admissible, I think we have to work in reverse chronological order here and deal with the issue of cause of death of George Floyd on May 25th of 2020. Because that is clearly a contested issue in this case. The medical examiner has opined that the cause of death was cardiopulmonary arrest, complicating law enforcement subdual, restraint, and neck compression. The Armed Forces medical examiner concurs with that result. Medical examiner Dr. Baker also noted significant conditions of arteriosclerotic and hypertensive heart disease, fentanyl intoxication, and recent methamphetamine use. The defense expert, Dr. Fowler, has opined that the cause of death was cardiac arrhythmia due to arteriosclerotic and hypertensive cardiovascular disease during restraint by police. There seems to be a commonality that there is a cardiac incident here, cardiopulmonary arrest, cardiac arrhythmia, noting arteriosclerotic, but most importantly, hypertensive heart disease, and also the presence of possible drug toxicity. I would also note that one of the plaintiff's experts, Dr. Chauvin, cited a study which stated that clinical signs of fentanyl toxicity include severe respiratory depression. So the cause of death is clearly at issue here, the defense theory of the case being that it is due in part to drug toxicity and not to positional asphyxia or other causes. The state and its experts opine otherwise, saying that it is positional asphyxia and the restraint that was placed on George Floyd by the defendant. Clearly there's a cause of death issue here. In fact, it is highly contested. The fact that we have cardiac involvement and hypertensive heart disease leads me to question whether there is anything from the May 6, 2019 case that is relevant on the issue, the medical condition, or the mechanism of death, because that seems to be the primary issue. What is the mechanism that caused the cardiac arrest or cardiac arrhythmia, depending on which expert you talk to? Is there any medical evidence that would contribute or be probative as to cause of death? On May 25th, 2020, the date of Mr. Floyd's death, there is a very similar starting situation as on May 6, 2019. That is, an officer approaches him while he is seated in a car. He is at gunpoint. The police have a gun pointed at him. And the May 25th, 2020 was Officer Lane. They both holster their guns at some point, but there is a shocking interaction between the police and Mr. Floyd. Shocking to Mr. Floyd. That is fairly clear. There is also evidence of drug concealment upon being stopped by the police. Basically concealment by ingestion. In other words, that he was eating and otherwise hiding drugs. On the May 25th, there is evidence of that from a white object of some sort being seen in a photograph from a videograph. There is a pill in the backseat of the squad that he was ultimately taken to and through, which has Mr. Floyd's DNA and saliva, both, in the back of Squad 320. Toxicology results showing fentanyl, which is, as we all know, a powerful opiate, and methamphetamine. The defense theory as part of the drug toxicity is what contributed to his death. So how is May 6th, 2019 relevant to that? Well, there are certain things that are not relevant. Mr. Floyd's emotional behavior is not relevant to cause of death once he is pulled out of the squad car. His statements, while they are very similar to what was said on May 25th, don't really establish anything other than perhaps his mental state. And as I think the state correctly notes in its memo from yesterday on page 3, Mr. Floyd's internal motivations on May 25th are immaterial. Whether he was genuinely anxious, claustrophobic, or suffering a panic attack, or whether he was malingering, is of no consequence. He was exhibiting certain behaviors which are evident on both videotapes, both May 6th, 2019 and May 25th, 2020. But they were the behaviors, regardless of their source, regardless of their motivation, whether they were due to anxiety or due to malingering, doesn't matter, because it is the behavior that the officers in both cases were required to deal with. The behavior is remarkably similar in reviewing the tapes. However, that does not make the emotional behavior of Mr. Floyd admissible. Accordingly, that part of May 6, 2019 is not admissible. Generally, what he is saying up until the time he talks to a paramedic is not admissible. Nor the fact that the officers said this was part of a narcotics investigation and they suspected Mr. Floyd of dealing drugs. Not relevant. Not admissible. The only thing that is relevant, again, we have to keep in mind, for cause of death. Any other purpose for which this is offered is not relevant and is unduly prejudicial and outweighs the probative value. But as to the point of cause of death and medical condition, May 6th is relevant. There is a modus operandi to conceal drugs in part by ingesting them, but also doing so in a very stressful circumstance. That is, being pulled out of a car at gunpoint and handcuffed. And so, what is relevant in the May 6, 2019 case that goes to cause of death or medical condition is essentially the video of the body-worn camera would be admissible from the time that the one officer approaches Mr. Floyd on the passenger side of the vehicle, the subsequent behavior with regard to eating drugs or not, his delay in complying. Again, when we get into resisting or complying, I don't think that is of any consequence. It is delaying in compliance, allowing him to ingest drugs, but more importantly, that heightens the stress on everyone, but most importantly on Mr. Floyd. Being pulled out of a car at gunpoint, I am sure, caused him great stress and was a very shocking incident. The only reason we know that this is relevant to cause of death and is probative is that subsequent to taking drugs while being encountered by police, similar to May 25th of 2020, Mr. Floyd was checked out by a paramedic. Everything leading up to that conversation with the paramedic is not admissible beyond that initial video up until the time Mr. Floyd is out of the car. Even the videotape, the body-worn camera, which I think was actually just placed on a table, of the paramedic's conversation with Mr. Floyd is also not admissible because it does contain some of the emotional behavior which is not admissible. But the paramedic can testify as to that this person was called to the scene to examine Mr. Floyd, to treat Mr. Floyd, and in doing so, he made certain statements which would be admissible as statements made for the purpose of medical diagnosis, specifically how much drugs, what kind of drugs, and the timing of the drugs, when the drugs were taken. Those could be hearsay, but it does fall within the statements for purposes of medical diagnosis. The other statements of Mr. Floyd are not admissible. The examination then discovered, and I don't have the exact numbers, and I didn't have the, I apologize, I don't have the timestamps or the exact, because I reviewed this last week. But it's my understanding that the blood pressure that was found was 216 over 162, or something in that neighborhood. It was over 200 for the systolic and over 160 for the diastolic. And I hope I got those right. But in any case, that's more than just a history of hypertension. It is clear from other records that Mr. Floyd had a history of hypertension. But what this shows, this blood pressure, is that he is now in a hypertensive emergency, such that the paramedic said, you have to go to the hospital because you could have a heart attack or stroke. That statement by the paramedic is not admissible. The reason for that is, as the state said, notice to Mr. Floyd that is not relevant. There's no really reason why he has to be told that. On the other hand, the paramedic can explain her actions in recommending to Mr. Floyd to go to the hospital because I'm sure her training is a blood pressure that high means someone is in a hypertensive emergency, and hypertensive emergency with a blood pressure that high can cause cardiovascular, cardiopulmonary complications. So the paramedic can testify as to why she recommended to Mr. Floyd to go down to the hospital. That does not mean that her video statements to him are admissible. I think it makes more sense for her to explain why she took the action she did. The subsequent treatment at the hospital, and the defense noted that Mr. Floyd was violent or otherwise, none of that is admissible. So what we have here, what I'm going to allow, is a portion of the videotape of the one officer from the time he approaches the car until Mr. Floyd is out of the car and handcuffed. And I apologize, I don't have a timestamp, but it's very clear that there's a shot of the back of his shirt. He's wearing a black shirt. At that point, he's been handcuffed. That's all that would be admissible. The pills that are in the crack of the seat would also, there's a photograph of that would be admissible also as part of that scenario. And then the blood pressure and Mr. Floyd's statements that were made for purpose of that medical diagnosis. The whole point here is we have medical evidence on what happens when Mr. Floyd is faced with virtually the same situation. Confrontation by police at gunpoint, followed by a rapid ingestion of some drugs. We don't know exactly how many, but there was an admission that he had done it at the time of the stop. That is medical evidence. So we don't have the benefit of on-the-scene medical vital signs on May 25th. So the May 6th, 2019 case is relevant only to that extent. Mr. Floyd's emotional behavior, calling out for his mother, all that is not admissible because the emotional behavior in his state of mind is not relevant. The May 6, 2019 evidence is only admissible for the limited purpose of showing what Mr. Floyd's as an example of Mr. Floyd's bodily reaction, his physical symptoms upon being confronted in almost the exact same situation. Now, how does this affect the decision on Dr. Vincent's testimony? Dr. Vincent's report and her testimony would be strictly psychiatric evidence going to the state of mind of George Floyd. As I've said, this is not admissible. It's not by either side. The behavior itself is manifest on the videotape. And I believe the state has one expert who would say, the behavior you see on the videotape is not consistent with a cardiac arrhythmia. Perfectly appropriate opinion based on what they see on the videotape. To go further and say, have a psychiatrist say, this is due to or just consistent with anxiety, hypertension, or not hypertension, anxiety, claustrophobia, panic attack, really is just opining on the state of mind of Mr. Floyd and the mechanism or why he's acting the way he is. If the defense were to attempt to say that he's simply malingering, that would be speculation, and I would not allow that either. Because Dr. Vincent's testimony would go to the state of mind and interpreting the emotional behavior and its cause, that is anxiety, panic attack, claustrophobia, or even PTSD, is not admissible. Having said that, if the state believes that there is something the defense has done to open the door, we can discuss off the record or at least outside the hearing of the jury if the defense has opened the door to Dr. Vincent's testimony. Keep in mind that would be in rebuttal. Keep in mind further that if I allow Dr. Vincent's testimony, then the entirety of the May 6th case would be in, because the defense would have a right to confront her opinion by playing the entire videotape of Mr. Floyd's emotional reaction on May 6th. And I think this illustrates both the benefit of motions in limine and the disadvantage of motions in limine. Number one, the benefit is we can try and parse through a lot of these very detailed evidentiary issues before trial so that we are not taking long recesses to discuss and brief while the jury is waiting. And so this is absolutely appropriate that this was dealt with by motion in limine. The disadvantage is we cannot, to every extent, script out this trial. Trials happen in real time, and there is just the true nature of it that things change. So accordingly, let's go with that idea, is that if the state feels that the door has been open, we'll have a conference about that and I'll decide. But keeping in mind that if it is open, it's probably open to all the evidence regarding Mr. Floyd's emotional behavior and its evaluation. So that is the court's ruling. We're going to try and get as much of this down into a written memorandum. Over the weekend, Mr. Schaefer and I will be putting in some time to firm this up. But that is the limits that the court will allow. I think this is consistent with the Ness case, which said that it can only be for a limited purpose, and the amount of evidence regarding that limited purpose has to be limited as well to try and keep out as much prejudicial matter as possible. Now, as to the motions for continuance and for change of venue. The purpose of a change of venue is to ensure that the defendant has a fair trial by an impartial jury. The same is true as the basis for the defense's latest motion to continue, with the hope that as time passes, people forget some of the pretrial publicity. Unfortunately, I think the pretrial publicity in this case will continue no matter how long we continue it. Perhaps some of it may, with time, be forgotten by people. And as far as change of venue, I do not think that that would give the defendant any kind of a fair trial beyond what we are doing here today. I don't think there's any place in the state of Minnesota that has not been subjected to extreme amounts of publicity on this case. Change of venue is an option in the rule, when there is extensive pretrial publicity that is prejudicial. And there was prejudicial pretrial publicity, including the latest actions by the city of Minneapolis in settling the case. I'm not questioning whether they could or should settle the case at this time, but the bottom line is when it's reported by the press, it can affect the jury, it can prejudice or taint our jury pool. I'll be very honest, when that was first brought up by the defense, I thought they were overstating. I thought this really won't have an effect. People know it's a different case, different situation. I was a little shocked when we called back all the 9 jurors who had been seated, and 2 said it did move them off of being fair and impartial. We had all accepted them as fair and impartial jurors. 2 of them basically said that they could not be fair and impartial any longer. I was surprised that it had such an effect. That's probably a judicial bias. As a judge, I'm used to, okay, that's not relevant, so I'm just going to put it aside. So it is easy for me as a judge to disregard the fact that the city settled, knowing that it's totally different factors. But I have to remember that that's not the point of view that jurors are coming from. And so 2 said that they could no longer be fair and impartial. They were stricken. That left us 7. It is important to note that the other 7 did not feel that it was going to change their ability to be fair and impartial. Ultimately, on a motion to continue to ameliorate prejudicial pretrial publicity and continuance or change of venue for those purposes, is to find a fair and impartial jury. We have had 8 full days of voir dire from March 9th through March 18th, and now we're going to continue, hopefully, to select 2 more jurors. We had an initial jury pool of 326 from the random draw on February 1st based on all the summons jurors who returned questionnaires. We have gone through 95 panel members as of March 18th. 57 have actually been questioned. 22 were excused for cause on the parties' joint motion based on the review of the questionnaires. 16 were excused from the panel by the jury office between February 1st and March 18th after having completed questionnaires due to postponements, ineligibility criteria, for example, no longer resident of Hennepin County, non-citizen, over the age of 70, health-related, etc., but prior to questioning. Of those 57 panel members whom we have actually questioned during the 8 days of voir dire, we have selected 12. Defense has exercised 12 peremptories. The state has exercised 6. And the court excused 27 for cause after individual questioning. I think it's worthy to note that I did give both sides extra peremptories. And people may wonder, how does that help? If I'm not going to change venue and I'm not going to continue the trial. There are jurors who are very clearly incapable of being fair and impartial. Some will come right out and admit it. Those are the easy ones. The court can excuse those when they say, for whatever reason, I cannot be fair and impartial. The next set are those who the court makes a finding that based on the totality of the circumstances cannot be fair and impartial. As I've said a few times during voir dire, just saying the magic words, they can be fair and impartial, does not end the court's inquiry. The court has to consider the totality of circumstances and decide if it has been established that they cannot be fair and impartial. There's a third class of jurors who don't say enough to establish a challenge for cause. Yet there are concerns that they still might harbor certain biases, and maybe it's rarely that they are lying to the court or to the parties. It's usually that they just have not done sufficient introspection, to be honest, and see how their biases affect them. It is for that reason that a peremptory challenge can be made if the parties believe that a person cannot be fair and impartial, that they would be biased against their client, be it the state of Minnesota or the defendant. That's the purpose of peremptory challenges. More were given after the settlement announcement because that would add an added layer of potential prejudicial pretrial publicity. And so to get at that third group, which might have grown in size because of their exposure to the settlement, that's the purpose of giving both sides additional peremptory challenges, to focus on that third group, which although they heard about the settlement, said they could be fair and impartial, but we all, or some, the striking party, had concerns that they could in fact be fair and impartial. And that's an appropriate exercise of peremptory challenges. Obviously, challenges based on race or gender, and that being the reason for the strike, are improper, and we've dealt with those on the various challenges that have been brought. With that, we'll continue with jury selection. We will continue with jury selection in this case and in this county. Accordingly, we'll take a break till 9 o'clock when our first juror is here. So we'll stand in recess until that time. Thank you.